He would, but not in, he wouldn't call it cocaine. He would use codes.
What did he call it?
Records. Usually he was in entertainment, so he would call it records.
And what did a record mean to you?
An ounce.
So if he said, take 2 records to Mr. X, he was telling you to deliver 2 ounces of cocaine?
Yes.
During the time that you were delivering cocaine and selling it, did you have a legitimate source of income, a regular job?
Yes, I did, but it slowed down that at one time it was my only source of income.
The sales of cocaine?
Yes, sir.
Did there come a time when you stopped doing business with Edgar?
Yes, I did. I stopped doing business with him in about February of '84.
Why was that?
Because he wanted me to make a house payment for him, saying that I owed him some money, which I didn't, and I told him I just wouldn't deal with him anymore.
And after you had this falling out with Edgar, did you ever deal coke again?
Yeah, I quit for about 3 months, and then I went to New York on a business trip for a clothing show in the New York Coliseum, and ran across an acquaintance, and this one person made me an offer that really made me wonder whether I should go ahead and do it or not.
What kind of offer did he make to you?
He offered me cocaine at about half the price of what I was usually getting it.
Now, you've been paying Gomez $2,200 an ounce, I believe you said.
Yes.
How much did he offer you cocaine for in New York?
He offered it, initially he offered me a pound of cocaine for $20,000, whatever that broke down to be, and then I thought about it, and then he came down to $15,000, and I didn't have any money with me, and he worked out a deal where I took 4 ounces with me, and he didn't charge me, and the compromise was for me to send him the money back in about a week or 2 weeks.
How much did he sell you the 4 ounces for?
$3,500.
So now you're down to a little less than $900 an ounce, whereas you've been paying $2,200 an ounce in Anchorage.
Yes, sir.
Now, what did you do with that, those 4 ounces that you got in New York?
I took it back, and I sold it to 2 different individuals.
Who were those individuals?
One was name was Dave, and the other guy was Frank, as I know him.
When you got back to Anchorage with 4 ounces of cocaine, did you just sell 4 ounces?
No, this friend of mine, Dave, the one client that I got after I got started in the business, he taught me how to cut the cocaine with this thing he called vitamin B complex, but he brought me a bottle that he said he bought at a head shop, and I would mix 7 grams of that to an ounce, so out of the 4 ounces I turned out with 5.
There are 28 grams in an ounce, so if you add 7 grams per ounce to 4 ounces of what you thought was pure coke, you've still got 5 ounces of pretty good coke. Is that what you're saying?
That's correct.
Now, how pure was the coke you brought up from New York?
I don't know.
What was the stuff you cut it with?
The stuff I cut it with was vitamin B. It said mannitol on the bottle.
Did you know what it was?
What, mannitol?
Yeah.
Vitamin B complex is what this guy told me.
And that's all you knew about it?
Yes, sir.
In fact, in all the time that you dealt coke, did you ever know for a fact how pure the coke was, or in fact that it was coke at all?
I never tested it, no.
How much did you make on the sale of the 5 ounces of cut cocaine that you brought up to Anchorage?
I netted about $9,500.
Did you decide to go back and get some more from New York at that price?
Yeah, there was this individual, Frank, which was after me about getting him a pound of cocaine. And since I had this connection in New York, I went ahead and made arrangements to get a pound from New York.
At the going rate of $15,000 that you'd arranged?
Yes, sir.
But Frank wasn't what he seemed to be, was he?
No, sir.
What was he?
He turned out to be an informant.
And that's how you wound up in jail?
Yes, sir.
think you told us you weren't the only guy delivering for Gomez. In fact, the people that you were delivering to on behalf of Gomez were purchasing roughly an ounce or 2 ounces per week themselves. Is that right?
Yes, sir.
And at that quantity, they were purchasing for resale themselves.
Yes, sir, they wouldn't use it all.
That's more than a person can use in a week.
Oh, yes.
Right now, today in Anchorage, is cocaine freely available?
Yes, I would say it's very easily available.
If we took you back today and turned you loose on the street, could you buy some?
It's possible, yes, that any newcomer into town could actually go to just about any nightclub and say, hey, I just got here, and could you see if you can get me some, and they could probably come up with something.
Mr. Chairman, I have no further questions for this witness.
Any questions from the panel? If not, thank you very much for your testimony and cooperation today. It's duly recognized.
Thank you, Mr. Suarez. Mr. Suarez has also submitted a prepared statement for the record, Mr. Chairman. I'd ask that it be made part of today's record.
So be it.
On the original agenda for this day's hearing, Mr. Chairman, there was an additional cocaine trafficker whose testimony we had sought concerning his career distributing cocaine in what we considered the geographical heartland of America, specifically Lincoln, Nebraska. Last night, in his final preparation to testify here, that witness indicated that he had grave concerns for his own personal safety. The evidence in possession of the Commission staff indicates that there is a credible basis to believe that there was a threat to his safety. We were not able to guarantee his safety in that short notice and to guarantee his safety after appearing, and we have elected not to present him today, and he will not appear here.
And just so the record's straight on that issue, we have been very successful in obtaining the assistance of the United States Marshal Service and the FBI and the Drug Enforcement Administration, and given proper notice, we're more than amply able to take care of witness situations like that where we deem their security is necessary. But such arrangements are, if you don't know about the risk until a later date, it's impossible to make those arrangements of adequate nature on such short notice. So we'll put that over for possible hearing, his appearance at a later hearing.
I would like to indicate, Mr. Chairman, since I handled those discussions, that what you said is absolutely correct. And I would add that even on this short notice, I believe that arrangements could have been made if the witness had not declined such arrangements as could have been made for his safety. As he did decline those arrangements, we were not prepared to put his physical safety at risk.
Thank you, Mr. Smith.
Should we presume that the testimony would show essentially the same situation in Lincoln, Nebraska?
Yes, sir, with the added fact that during the time that the Lincoln, Nebraska trafficker was selling and distributing cocaine in that city, he also held a position of employment that involves substantial responsibility for personal safety and property, and he would have admitted the use of cocaine and other drugs while he was in that position of responsibility.
At this moment, I understand the staff wishes to take a short break to arrange for a next witness who will need certain security arrangements. Will 10 minutes do it, Mr. Harmon, instead of 15?
Yes, Mr. Chairman.
The hearings are national in scope.
Well, we had planned to pool our money together to be able to purchase narcotics at a cheaper price. We would pool our resources to make sure that we had materials to cut with. As a council member, we had formed a leasing corporation so that we would have rolling stock, automobiles for our women and for our friends, and to carry on our business.
Teamster Union leader Jackie Presser appeared before a presidential commission today not to answer questions about ties to organized labor, but, as Rita Braver reports, his alleged ties to organized crime.
Teamsters President Jackie Presser today.
Mr. Chairman, on the advice of counsel, I respectfully decline to answer that question on the grounds of the Fifth Amendment.
Teamsters President Jackie Presser last August.
That we are endorsing Ronald Reagan for president and George Bush for vice president.
In what some administration officials acknowledge is an embarrassment, the man who hobnobbed with top Republicans at their national convention, the president's strongest labor supporter, was called before the president's Commission on Organized Crime. The commission is investigating charges against Presser, including charges that he took payoffs from a mob-controlled labor leasing company. A hooded witness, a government informant and former employee of the corrupt company, said that in the 1970s, he delivered cash to Presser in return for labor peace.
So in the meantime, I got Jackie to come in. I got a hold of him. I gave him his envelope. I said, Gene told me to send this, to give us to you.
But on this and other questions, 15 times in all, Presser took the Fifth Amendment. He said it would prejudice his rights in another investigation.
I have been the principal target of a 4-year investigation in Cleveland, Ohio. In January 1985, the Cleveland Strike Force recommended my indictment.
If indicted, Presser would face charges that he ran a scheme in his Cleveland local to pay union officers who didn't really do any work for the union. Today's hearing turns the spotlight not just on Jackie Presser, but also on the Justice Department, which must decide whether to follow its prosecutor's recommendation and indict an important supporter of the president. Rita Braver, CBS News, Chicago.
Commission will come back to order. Mr. Harmon, call your next witness.
Nicholas Deek. Mr. Marshall, would you please swear the witness? Mr. Deek, would you please rise?
Please right hand, sir. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you guys. I do.
Might, Mr. Harmon, I noticed that Mr. Deek is present with counsel, or at least, I believe it's counsel. Maybe counsel could identify themselves for the record.
Yes, Mr. Chairman. My name is Stan Mortensen, and I'm with the law firm of Miller, Cassidy, LaRocque, and Lewin here in Washington. I appear here on Mr. Deek's behalf.
Mr. Deek is, for the record, well represented. It's a very fine law firm, and your reputation precedes you.
Thank you.
Mr. Mortensen, I've been advised that Mr. Deek wishes to make an introductory statement. Is that correct, sir?
Yes, Mr. Deek.
Yes, Mr. Harmon, I would like to make an introductory statement. And however, with the permission of this commission, I'm going to ask Mr. Mortensen to read the statement. His voice and his accent comes through much better than mine.
This statement by Mr. Deek, I will read. I would like to just...
Excuse me, Mr. Chairman. I understand that our rules require that witnesses present sworn statements in one fashion or another. And perhaps if Mr.
Mr. Deek been sworn?
Yes, sir.
Mr. Deek's been sworn. Counsel is reading a statement that Mr. Deek adopts.
Yes.
There's no need to have counsel sworn.
All right. Thank you.
Do you understand, counsel, you are operating as Mr. Deek's agent, and you are giving us a statement that he authorizes and approves?
That is correct.
We are free to ask Mr. Deek questions concerning the statement after you've given it.
Absolutely. I would like to describe for the Commission the extensive efforts...
Mr. Chairman, I object to this procedure.
I also object, Mr. Chairman. I believe since this is a sworn witness, the witness himself should be reading his own statement.
Do you want to go ahead?
Well, Mr. Deek, I think they have more confidence in your articulation than you do. And I must, having heard you speak here briefly, I think we will probably be able to understand you. So I don't think we'll have any problem at all. So rather than spending any more time on this issue, I would ask that you read your own statement. And if counsel you want to amplify anything, please comment to Mr. Deek and ask him to do that.
Mr. Chairman,
might be just as easy.
I will do my best.
Well, you'll do fine, Mr. Deek. Don't worry about it.
First of all, I want to express, the pleasure of being here and giving you my version of the situation in which you are interested and which we are trying to explore here, and I try to be as helpful as possible. I would like to describe for you the extensive efforts which we at DIC Pereira have made to comply with and support federal regulation, and I would like to address quickly some of the statements made about DIC Pereira in the Commission's report. I also would like to discuss some concrete proposals for improving the regulation of financial transactions. DIC Pereira's procedure for currency reporting compliance begin with extensive staff training, including written instructions from the legal department, from our legal department, special information-taking forms, seminars by the legal department, and periodic reminders from management. A 24-hour hotline service is provided by the legal department for our faraway offices to answer staff questions concerning currency reporting compliance. Each DIC Pereira office in the United States and United States territories and possessions has at least one person expressly designated to supervise a compliance function. That person is responsible for reviewing systematically every transaction handled by the office to determine whether a currency report must be filed and for ensuring that each required report is properly filed with the Treasury Department. Any staff errors are caught and corrected before they can be repeated. The staff responsible for compliance receives in-depth training from the legal department, and each compliance officer receives a comprehensive manual created by the legal department which supplies legal advice and guidance. In addition, periodic unannounced audits are conducted at our offices throughout the United States under the legal department's supervision to ensure proper understanding and application of the law. All offices prepare monthly reports for the legal department on the number of forms filled and filed. In these monthly reports, the office manager and the compliance officer must each certify that proper procedure have been followed. Despite all these efforts, we had compliance difficulties in 1978 and earlier. Because these problems were mentioned in the Commission's interim report, I would like to correct a couple of possible misimpressions in the record. I'd like to take the Orozco case. The interim report, your interim report, ladies and gentlemen, incorrectly suggests on pages 42 and 43 that our New York subsidiary committed currency reporting violations in connection with the so-called Orozco case, and further implies that our subsidiary somehow concealed Orozco's financial activity from the government. In truth, however, our New York subsidiary filed currency reports for each of the Orozco-related cash transactions, for each transaction. By March 1982, government already had in its possession approximately 180 written reports filed by our subsidiary concerning Orozco-related transactions. All of our subsidiary currency reports filed in connection with Orozco were reviewed by the Internal Revenue Service and the Customs Service during the 1982 audit, and by the United States Attorney's Office in connection with the persecution of Orozco. To date, none of these agencies had advised us of any violations in connection with those filings. Further to the management's knowledge, no such violations exist. As a matter of fact, we feel that we called the attention of the government to the Orozco case and prompted the investigation of the Orozco. Now, concerning the Isaac Catton matter, on pages 42 and 43 of your interim report refers to over 1,266 allegations of currency reporting non-compliance by one of our New York subsidiaries during the 1977-1978 period, including allegations concerning Isaac Catton. Our subsidiary has filed with the Treasury Department a petition for remission and mitigation of the $572,000 penalty assessment proposed by the Treasury Department in connection with these allegations. To put into context the numbers mentioned in the report on this subject, it is a matter of public record that these allegations relate to a period during the 1970s when there was widespread confusion concerning the interpretation and application of the law, and a high degree of technical non-compliance was endemic to the industry. According to the 1981 General Accounting Office report on currency reporting, a customs service study estimated that during early 1978, as many as 50% of the Federal Reserve member banks were not filing between 10% and 90% of the required reports. The California case. The interim report mentions our San Francisco subsidiary, 1978, conviction for currency reporting violations. The proof at trial, however, included evidence that the manager, who was immediately fired when the violations were discovered, had violated company policy and had concealed his failure to file the forms from the company. This was the only time, to management's knowledge, that any member of our group was ever convicted of a criminal violation of any law. I am coming now to the recommendations I like to make to this commission to improve the system of reporting and spotting of illegal money transactions. In our industry, at the present time, we are using two types of forms to cover different types of transactions. One relates to the import and export of currencies and of negotiable instruments.